case briefs, and so much more. LSData's got what you're looking for.
In 1983, the United States Court of Appeals for the Third Circuit heard the case of Novosel v's Nationwide Insurance, which focused on whether employers could fire employees for refusing to participate in activities that violate public policy, and whether certain protections against wrongful termination could be read into at-will employment contracts. At issue was a lawsuit brought by John Novosel, a former employee of Nationwide Insurance Company, who claimed he was wrongfully discharged and that there was a breach of an implied contract of continued long-term employment. Novosel claimed he was fired for refusing to join the company's political lobbying efforts and expressing disagreement with its stance on the No-Fault Reform Act before the Pennsylvania legislature. He argued that his discharge was arbitrary, malicious, and in bad faith, and went against public policy. Novosel also claimed that as long as his job performance remained satisfactory, he had an implied contract of continued employment. Nationwide Insurance Company filed a motion to dismiss the case, which was granted by the district court. However, Novosel appealed this decision, and the case was remanded for further proceedings. The Court of Appeals held that Novosel's wrongful discharge claim fell under emerging tort case law and had to determine whether his complaint provided a sufficient basis for a successful tort action. The court found that Novosel's case could have causes of action implied from the Pennsylvania Constitution, as his complaint disclosed no legitimate reason for termination and violated a clear public policy mandate. Therefore, the case was remanded for further proceedings consistent with this opinion.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.